Hi guys, hope you have understood my last two classes. This is the third class that I'm going to take here. I'm going to tell you what are the different things which is necessary in a contract. Okay, we understood what a contract is. We understood what agreement is. We understood what a social agreement is. What is enforceability of law. All these things we understood. All right. Now next thing what is important is here in a contract, to form an agreement, there should be an offer and there should be an acceptance. That means minimum two parties is compulsory in a contract. An offer should come from one person about something, and the offer that is giving to the opposite party, that party, if he or she accepts what you are offering, then she is called the offeree or the acceptor, and the person who is offering is called the offerer or the promiser. Hope you guys understood. See, I am promising you, or I am offering you my car. So I am offering you to sell my car for around 1 lakh rupees. I am asking you if you are interested. You see the condition of my car, you understand every other thing, every other aspect of it, and you say, yes, I want your car. I am ready to accept your offer. So I have given you my offer and you have accepted my offer. I have promised you. So the offer who is giving the offer, I mean the person who is promising that I will give you my car for 2 lakh rupees as agreed, then I am a promiser and I am also called as an offerer. Alright, so the person who is offering is called the offerer, and the person who is accepting is called the offeree or the promisee. So there are two names over here. The person who is offering is called the offerer or the promiser, and the next person, that's the opposite person who is accepting it, is called the offeree or the promisee. Alright, so these are the two different characters in a contract. All right, so without an offer there will be no acceptance, and if there is no offer and no acceptance, there will be no agreement, there will be no contract. So these are the two important parts of a contract. All right, and now next we will learn a few essentials of a contract. Now, what is essential? Many students fail to understand what exactly is essential. They feel it is the characteristics or it is something different. It is not characteristics or something like that. The essentials of a contract means if you want to place this particular contract word under the word contract in legal, then there are certain things that should be fulfilled to make a particular agreement a contract. Otherwise it can be called as an agreement, or it can be called anything. So if you want to understand what exactly is contract, how can a contract be performed, or under a contract if you want to file a case against anybody, then you need to know the exact concept of contract, what all things are necessary in in the word contract, and that is called essentials. Okay, so essentials, the first essential is there should be minimum two people, minimum two parties in a contract. One single party cannot perform a contract. So one will be there for giving an offer and the other person will be accepting the offer. So the offerer, offeree, or the promiser, promisee. This is the first essential. You can place it anywhere here and there in the for your exams, doesn't matter, but here when I'm saying this is the first, it doesn't mean that you should be mentioning this particular essential on the top level. It's not like that. Okay, you can put it in any ways, doesn't matter. So the first one is there should be two parties. All right, so second one is there should be an agreement. Now parties, you are just looking at each other and in your through your eyes you are mentioning something and an agreement happens. It doesn't happen like that. Okay, so you should be putting up some conditions, you should be putting up your what to say, your statements which you want to make in the contract paper, and the other person also has to accept it. This is the most important thing. It is not only you that you are offering and you put up all the conditions, and the opposite party, just because he or she said yes to your contract doesn't mean they do not have anything. Yes, both of the parties have their own conditions to be kept in the contract. And when you keep any conditions, or when you mention about the different points in that particular contract, it should be given consent. I mean, you are giving some point. You say that, see, this particular contract should be performed on 17th of January 2025. This is what you have said. And the opposite party, if he or she says that no, on 1st of January 2025 I will not be available, I will be in America, or I will be somewhere else, or I will not be there, if that particular person says that, then if he is not ready, if he does not give his consent means the acceptance, wherein he denies, or he not denies, wherein he rejects your proposal of keeping the particular contract on 1st of January 2025. All right. So if he or the she opposite party is ready, then only this point can be confirmed and mentioned in the contract. That is what you have to understand. All right. So both the parties should come to a point wherein both the parties should accept what they are saying. Only then those points can be mentioned in the contract. Alright, so there should be an agreement. This is the second essential of a contract. For the next essential, I'll come in the next class. Until then, if you have got any doubts in this particular video, do comment. I will be giving you the explanation. Alright, so see you soon with the next video.